Now, unfortunately, uh, the the dramatic and drastic steps that a court has at their disposal to prevent domestic violence lead to where some use it as a sword rather than a shield and to actually protect them when they are suffering domestic violence. I must say that I've been in many cases where I've seen pictures and there's been criminal convictions as well as the family law request for a restraining order, and it's severe domestic violence, and that should never be tolerated. But neither should a false allegation of something like that. So, um, one of the things I talk to clients about, kind of at the outset, if there's any indication that this is a possibility or that it is a relationship that's a little bit volatile, I discuss with them: are they going to be staying in the same house together? Because that inevitably could lead to a blow up fight, somebody calling the police. And I've even been able to prove in court, for instance, that after a police call, the other party scratched themselves, with this hand, like across the side like that. And so, my client was taken in, and because of the injuries, the visible injuries, was put into jail overnight because of that. It wasn't something that we could quickly, unfortunately, we couldn't quickly overturn this because the criminal system hopped into place and gave an emergency protective order. The family law system followed up right behind and gave a 21-day domestic violence restraining order. And those have dramatic effects on the person who is charged with that. And to be honest, I mean, there is domestic violence, both male and female. I've been a part of assisting in the prosecution of both of those. But I think that statistics show that well over 90% of that is done by men. So in this instance, this might be one of the things that the male might really want to consider and assess: is there an opportunity to have a false domestic violence claim given to them? A little bit about domestic violence restraining orders. The code only requires that you give 4 hours notice, telephonic notice. So it goes like something like this: someone claims domestic violence. You call at 9 a.m. and leave a message. If they don't answer on their cell phone: I'm seeking a domestic violence restraining order in court on the 5th floor of the court, Department L64. And that's all they get. I'm going to, when they get that answer, hopefully they get it within the 4-hour time period and can go to court and provide a response. But if they don't, or some people don't believe that's a proper way to give notice, because it normally would not be. So you've got to act quickly. If someone gets a telephonic notice, they need to get an attorney quickly. If they can't in that time frame, they need to get down there to the court themselves and write a reasonable response. So how to prevent this? One, clients need to assess how much at risk they are. Is staying together going to be a situation that's going to lend itself to a false claim? And if it is, my suggestion is you may really want to think about moving out. If you don't move out, there's some technology out here that can be of assistance. Now, I'm going to back up a little. California is a very private state. The privacy rules for individuals are high. In some states, you can record a telephone conversation with anybody, as long as there is one person consenting, and that person can be the person who's recording. Well, California is completely different. It's a two-party consent state. You need to let the other party know you're recording them, either video recording, audio recording, telephone recording, whatever it is. And so, but there's some technology that you can comply with the law. One good one that I recommend a lot to people, because it seems like most people have an iPhone or Samsung or something like that, and the technology allows. There's an app. It's called Just Press Record. So I've got it on my phone to show people. I also have it. You can set it up on your Apple Watch, where there's a little red button, And if something happens, you can just say, boom, hit it. I'm going to record this conversation. Okay. Or pull out your phone, hit just press record, or hit the video. Video is probably the best thing possible. If you're letting somebody know or holding the video up in camera saying, I'm going to record this because you are attempting to make false claims, you've given them notice. They don't have to stand there and be recorded. You have a right to do that. And I can tell you that that has prevented many a domestic violence claim when it's turned out that perhaps the other party didn't tell their attorney that, oh, by the way, he or she recorded me falsely making claims. So that's one of the things. You want to be very careful on that. I'm not suggesting that that's the end all be all to preventing domestic violence, because in California, the penal code 632.7 describes what's required and that both parties need to have consent. And there's actually a family code, I think it's family code 2205, if I'm not mistaken, that essentially says that any information, it's 2022, I'm sorry, 2022, evidence that you receive by eavesdropping or in violation of that penal code that I described to you is inadmissible. So it's not one of those where, you can say, I put a bug on her car or in her house or whatever, and think you're going to be using that. That very well could turn you on your head and cause the court to suggest that the district attorney prosecute you for violation of that code. But done right and in consultation with their attorney, they can do things like I've said that are open and announced, because that's what the rule says. I'm recording you because you're making false claims, and get that statement to your spouse or to your girlfriend or your boyfriend, whoever it is, on the recording, so it's very clear that they know that that's happening.